Good evening, everyone. Thank you for joining us for our MU leasing series designed to help farmers and property owners with leasing arrangements. I'm Julie Harker, Kapner Extension News Strategist, and with me this evening is Amie Breshears, an Extension Regional Specialist from Warsaw, Missouri. Welcome, Amie.
Thank you for having me, Julie. I'm an ag business specialist in the West Central region located in Benton County, and I'm delighted to be here with you tonight. Thank you all for having me.
All right. Wanted to give you guys a quick reminder that just like last time, we're going to have questions that will be answered at the end of the program. So feel free to type in your questions at any point of the program, and we will take those at the end, as well as we may have time for a poll or two, actually. So Amie, do tell us a little bit more about yourself and what we can expect to learn from you on this session.
Well, as I said, I'm an ag business specialist, and I serve the West Central region of the state, the Lakes region, and the Prairies and the Ozarks here in Missouri. Two things I really want to make sure that we talk about tonight. One is what property rights are transferred in a lease, and the second is how leases are negotiated. So looking forward to going through those tonight with you.
Also want to have you give a very important disclaimer about this program and the information that we have tonight.
Yes, I do want to be clear that I'm not an attorney, I'm not an accountant, and am not in any way purporting to be so, but just want to share with you some general principles and some stories and things that I've learned in my work as an ag business specialist.
Amie, is it common to have misunderstandings in leasing arrangements?
Yes, I think unfortunately misunderstandings are all too frequent and often revolve around what a lease is designed to do. So one of the things that we want to talk about tonight is how to avoid those things.
Absolutely. Well, then is it safe or unsafe to assume that a property owner leases to the tenant, that the tenant then has control of the property?
So that's definitely unsafe without a lot of specifics in place. A lease transfers some rights, but not all of those rights to the tenant. Now, the property owner can do what they want with their land. They can sow a crop, they can harvest a crop, they can plant trees, they can cut down trees, they can build ponds, all sorts of things, as long as zoning is okay, obviously, if that is in play in their county. But when they create a lease, that transfers some rights, but not all, to the tenant. So certain activities may be excluded or included depending on the language in the lease.
Okay, so you had an example, I think, about timber harvest.
Yes, one of the things people may not think about is that when a piece of property is leased and they don't exclusively call out timber harvesting, for example, that might be something that a tenant could mistakenly assume is allowable if they don't specifically address that. And so I do think people want to be thinking through not only what's in their mind about how they've used their land and the resources on it, but how someone else might think about using it and making sure to address those issues.
Okay, we're going to delve into that a little bit further with this next video, this short video.
Ownership typically is defined as having a bundle of rights regarding a piece of property. The rights most recognized in ownership include the right of possession, of control, of enjoyment, of exclusion, and of disposition. Leases are a way for a property owner to grant some of their property rights to another person for a specific period of time. The owner can assign rights that she has to the property in exchange for what she wants, usually a rental payment. The tenant agrees to the conditions of the lease in order to gain the specific rights being offered. The right of property possession means that the owner has legal title to the property. With the right to possession may come the responsibility to pay regular licenses and fees, property taxes, and any liabilities or liens against the property. This right is not transferred in a lease. The owners still retain the legal title to the land and, usually, the responsibility to pay taxes and mortgages. The right to control means the property owner can decide what happens with the property. This right allows them to choose who can farm the land, occupy a building, or use a piece of equipment. As with all other rights, there are limits. The right to control is subject to regulations and laws. A property owner can assign specific control rights to a tenant. For example, she can assign the right to farm a field, but withhold the right to modify improvements such as grassed waterways, tree lines, or fences. The tenant assumes all the limitations in law and regulations that the owner has. If the tenant wants to participate in crop insurance, he will have to maintain conservation compliance on the land. The right of enjoyment gives the property owner the right to decide how their property looks and operates for their enjoyment. This is similar to the right to control, but has subtle influences on a lease. A landowner may give a tenant the right to farm a piece of land, but perhaps the landowner still wants to visit the farm, walk around, fish, or maybe spend the afternoon fixing a fence. The landowner would need to specify that he retains the right to these enjoyment activities. Without specifying the property owner retains the right to enjoyment by such activities, the tenant might think the property owner assigned them to the tenant in the lease. The right of exclusion is the right of the property owner to prevent others from trespassing or possessing their property. Of course, in a lease, the property owner specifically allows the tenant and their representatives to enter the land. Going back to the right to enjoyment, landowners need to be clear what rights to access the property they are retaining. Frequently, leases will state that the property owner can enter at certain times and for certain activities. Remember, a lease is a transfer of rights. A good lease clarifies the specific rights transferred to the tenant and the specific rights retained by the owner. The right of disposition is the right to transfer ownership of the property. The right of disposition also gives the property owner the right to assign her property rights to a tenant via a lease. The right to dispose of a property by sale or inheritance is subject to the duration of the lease. This means should the property owner transfer her leased property either by sale or by inheritance during the lease period, the lease is binding on the next owner. Some rights are never transferred in a lease. A tenant cannot dispose of or sell the property. Only the property owner can. Also, a tenant cannot use the property as collateral on a loan. Leases affect the financial positions of both property owner and tenant. That will be for another lesson.
All right, very good. So that was a bit about the transfer of rights to tenants. And I do want to remind you folks to ask questions. We do have one in the chat already, so keep them coming. So Amie, the video talked about the 5 rights of the ownership. So what really struck me was the right to control. Can you tell us more about that?
Absolutely. So property owners control within legal limits what they do on their land. And that gives them the ability then to transfer to their specifications that control that they do have. So, and some, but not all rights may transfer. So that is something that landowners want to be very careful in their lease to craft out and specify. And leasing really is a transfer of rights. So we want to be clear about what those rights are.
Mm-hmm. All right. So what about the rights to exclusion and enjoyment? Those are ones we might not normally think of, but how might they be transferred in a lease?
So that is really something that's important. And I might back up just for
Sure.
One thing I wanted to mention would be that an assumption, for example, that when we're talking about being specific, people need to think this way. For example, a family may have always used their a pasture for hay ground, and they might lease to a tenant who thinks that'd make great row cropping ground. But if they've never discussed that, they may assume it'll always be hay ground. The tenant can see nothing except it'd be great row cropping. And so that may be a disappointment for both parties involved. So I just wanted to just touch back about getting specific about limited control and rights and talking about that. So right to exclusion, right to enjoyment. People don't always think about their tenant's ability to do this, and the tenant may not always think about the landowner. Hunting rights are one example where this kind of becomes apparent. For example, a landowner's family may have used the piece of land to hunt for years, and they do a lease. The tenant may think this is a great place for me and my family to hunt. And so if they haven't talked about that, there obviously could be some conflict there. Also, does someone have exclusive use? So maybe the landowner still wants to hunt there, but is okay with the tenant hunting there as well, but maybe the tenant wants to be exclusive. So right to exclusion means I might have it all to myself, or right to enjoyment means maybe the landowner expects to go and enjoy it, even if they've leased it out for row cropping or whatever. Another thing to keep in mind is, does the tenant expect it? How does the tenant expect to keep it as far as looking, mowing grandma's home place or whatever? And what does the landowner expect? They may expect that it's always kept like they kept it. But if they don't talk about that or specify it, the tenant may not feel the same way and may not realize that that's something important. So exclusion, enjoyment, and then thinking about how the place is kept and what the family's priorities might be.
Right. So you don't want to make assumptions. So therefore, communication is the key here, especially in negotiating a lease. So we're going to look at another video that really drives that message home.
Americans typically dislike negotiation. We would rather have the price clearly posted and know the features before we buy something. The reality is that we negotiate every time we engage in trade. We just don't always recognize it. When we buy clothing at the store, we balance the traits of color, comfort, style, brand, and price. We trade off style for comfort, brand for price. The trade-off of different characteristics is intrinsically negotiation. Leasing is a negotiation between the tenant and the property owner. Like other purchases, leasing negotiations involve many traits, of which price is only one trait. Our aversion to negotiation might be because we focus on price, rather than consider the whole suite of decisions being made. Leases can be disappointing because the rental rate is not what was hoped for. But leases are often disappointing because of the way one party is doing something you don't think is right or fair. A tenant didn't keep the weeds under control. A landowner won't allow a multi-year lease. These disappointments arise because each other assumed something that was not discussed, was not negotiated. Assumptions ruin good relationships. Discussions that end in satisfying decisions can prevent disappointments. Never split the difference. A book by Chris Voss presents some useful principles for negotiating. Some principles Voss mentions in his book are: 1. Know your objectives well before talking with the other. 2. When talking with the other person, focus on his or her interests. And 3. Focus on how. Property owner and tenant both often start and end with the question of price. How much will be paid to lease the property? But the rental rate is dependent on what is being leased and what rights are being transferred. Transferring more rights may demand more rent. Crafting a good lease agreement requires a discussion of all of the who, what, when, where, and how questions, not just the price question. Before the discussion, acknowledge your own objectives. Are you interested in annual rental payments that meet your living needs? Or are you more interested in the long-term investment potential of the land? Do you have some ethical considerations, such as improving wildlife habitat or maintaining clean water? Do you have social objectives, such as helping young families in the county? Is the other party interested in keeping the asset for a short time or a long time? What type of production can he do given his resources? Is this mostly a business opportunity, or does he also have family goals he's trying to meet? Voss, in his book, notes that negotiation is not a battle. It's a process of discovery. Discuss each other's objectives and resources and limitations. Discussion reveals which rights are needed, which can be transferred, and how extensive the decision-making power of each party will be. During negotiation discussions, focus on how. If the property owner is concerned about certain production practices, how she wants things done needs to be discovered. When a person suggests something, ask how that might be accomplished. asking how can reveal the difficulty of obtaining what the other person is suggesting. Good ideas survive. Bad ideas fade. Asking questions during negotiation accomplishes two things. The questioner gets to know the needs and desires of the other person, and the person being asked how can feel empowered rather than the weak party in the relationship. Discussions take time. For that reason, tenants or property owners should begin lease negotiations early. Waiting until a decision has to be made will prevent good discussions of important questions and answers. Give each person time to think through the discussion points before needing to make a decision. A negotiated lease meets the objectives of both property owner and tenant and specifies how things will be done. Good decisions might be forgotten without writing down the terms of the lease agreement. Put it in writing so you and others will understand what was decided.
All right, very good. I want to remind you to ask questions in the chat box and we'll get to them at the end. Amie, let's discuss this idea that was presented in the video that Americans don't tend to enjoy negotiating. How might that aversion show up in a leasing agreement?
So true. We were talking earlier about how when you go overseas, maybe, and you're at a vendor type market or street market, negotiating can be kind of fun. Haggling, we might call it.
Mm-hmm.
I've also seen people want to take, if it's a quarter at a yard sale for a pair of old socks, they'd like to pay 10 cents. So there are, that can happen. Some people really do enjoy it, but sometimes in a lease, and perhaps because it's more personal, maybe it's somebody we know well. We've got a big dream for this property that we want to lease. And so maybe it's a little more awkward. We're a little more fearful, or maybe at the garage sale, we have nothing to lose. So that may be part of it, where it just seems awkward and something that we try to avoid when we're talking about leases. However, negotiation actually involves which property rights to trade. So sometimes we think it's only about price. That's not really the case. It's also about which property rights to trade. For example, if a landowner wants a fence fixed, that might mean that the tenant is going to ask for a longer term for the lease. That has really nothing to do with the price. Really, they're talking about the length of the lease, and that yet is negotiation. It's not about price, but it's still a negotiation because it's talking about which property rights to trade.
Sure. Well, the video did bring up the key questions to ask: the who, what, when, where, why, and how questions. How are those useful in a lease if you follow them?
Well, for sure, they're going to keep you from focusing only on price. Okay. And we don't want to start with the price, because really the price is going to depend on what's being leased and what rights are being transferred. So to start with the price is maybe assuming a lot of answers to the questions that we've talked about. Negotiating a good lease requires that we talk about who and what and when and where and maybe why, and certainly how, not just the price. It's really a process of discovery, looking at having our needs met and also how we can meet our tenant or landowner's needs. It's very important that we know our objectives when we start. What is the thing that we want? As a landowner, they might be wanting income, but also they might want to maintain the quality of the farm or conserve natural resources. A tenant might also have a common interest in that, in taking very good care of the farm, maintaining the natural resources, because in the end, that may work better for them as well. So in the case like that, where there are similar objectives, they could both meet each other's needs. And the way they get to that is not by focusing on the price, but it's the answers to those questions that ultimately would lead them to a discussion about price, but that's not the only discussion.
Okay. So it sounds then like the question of how is very important.
Yeah, how in fact is the most important question. How causes us to consider from the other person's perspective what it would take to fulfill the thing that we want, what that entails on their behalf, the ease or the difficulty of accomplishing the goals that we have. And we can get to know them, and we should get to know them. For example, if we want to talk about soil improvement or cover crops, or as we talked earlier, fencing, that helps the person who wants those things think about what it takes on the other person's part to get to those things. It also keeps one party maybe from being or appearing the weaker party, because they can turn Rather than saying why they can't do something or shouldn't do something, they can ask how it can be done. And that turns the focus around. I think it also helps them think it through.
Sure. What about the question of when?
Yeah, so when the lease ends can be tricky.
Yeah.
Tenants usually want longer, especially if they're adding soil amendments or repairing fencing or putting in some kind of investment. An example of a conversation about this might be something like the landowner would say, or the tenant would say, well, I'd prefer a lease for 5 years. So here's an example of how to work that how in the question. The landowner would say, how can I commit to 5 years? So from that perspective, then the tenant's looking at it as a landowner and might say, well, we could shorten the lease if I'm reimbursed for unused improvements. So for example, if I put an amendment in the soil, and it's good for so many years, or I'm, with a lifetime of this many years, and then we do a shorter lease, then if you'll reimburse me for that, then I would feel okay about that. Or maybe we would add inducements for the landowner to lengthen the lease. For example, I will put lime on the soil, or I'll do something that is continuously improving it, which might help the landowner feel more comfortable with a longer lease. Again, the question how helps you get there.
What about those farmers who conduct leases on a handshake? And why is a written lease so important?
I think to some degree that goes back a little bit to the awkward, as if maybe you have something to prove, or that takes it to another level. But really, violation of verbal agreements is difficult to prove. In the event that it's terminated or may result in a court case, there's nothing that you have to prove anything. Also, as we saw in the video, a lease follows a land sale.
Right.
So the next tenant or the next landowner would need to know about that. How can you prove it if there's not something in writing? Written leases answer the why and the how questions. That makes every lease different. So if you have multiple leases, either as a tenant or a landlord, you can't be sure you remember all the details of those things.
Right.
And you certainly would want your heirs to know if they're the specifics of those leases in the event that something would happen to you. There's nothing that says you can't have a handshake after putting a lease in writing.
But get it down in writing.
You talked about a lot of things. If you answer all these questions, you spent some time, you spent some thinking, you need to record what you discussed and agreed on. It prevents differences of opinion in the future. It prevents hazy details, confusion. So you need to put it in writing, even though that may feel awkward. It really does protect everybody. And also, I will add, if you have any written communication, that's something you want to keep a record of, not as a gotcha or out to get another person, but just as a record of what we've talked about, what we decided, what we agreed on, how we're working together to help each other.
Great information. I'm sure you all would agree. We want to ask a couple of poll questions, and after we ask those and get the tallies, we're going to ask Amie a couple questions in between. This first poll is about what type of lease have you been engaged in? All right, so you have a single answer choice of written, verbal. I have both, and I do not currently have a lease. So we'll take a little time to get our replies in on that. And in the meantime, I wanted to ask you, Amie, what are things that folks might not think about that should be spelled out in a lease?
So I'm going to give you my kind of top Dave Letterman list, right? Top 10 type thing. So for sure, think about right of entry. Who can come onto the property, when, how often, maybe who can't. Okay. So certainly, are we going to let them cut the timber or not? If not, you're going to want to specify that. I'm going to guess most people will say no. Hunting and fishing, if there are ponds or there'd be some good hunting there, think about who can do that or not, and how often and when. Also, harvesting nut and fruit trees. Oh, yeah. That's not necessarily in every part of the state, but some parts of the state. If the trees exist, who gets to harvest and when and how often. Soil tests and fertilizer. If somebody's responsible for adding amendments to the soil or proving it with soil tests or for improving the soil, then those would be things to talk about and make sure that that's in writing. And how often and when and how you would communicate. For somebody who lives close, they might see each other in the coffee shop. For somebody who is a distant landowner states away, they might need to FaceTime or email. So that's a really important thing to avoid misunderstandings, as we talked about earlier, disagreements. Also, think about if you're if you are a farm tenant, think about how to help perhaps a non-farming landowner understand what it is you do and how you do it and maybe what you need to do. And so be thinking about educating that person as well and what goals that they might have, because they may have no farm background.
Very good. Well, let's look at the results of our poll on written or verbal leases. It looks like the vast majority, 47% have written, 20% verbal. There is a small percentage, 7% who have had both, and 27% who don't have a current lease. Would you like to speak to those results?
I think that that is very interesting. And so I think good for you if you have a written one, and good for you if you've had a verbal and it's always worked out well for you. Obviously, people need to make their own choices. I'm not an attorney or an accountant, so I can certainly advise that written is best. And I would even encourage those with verbal to take baby steps and work toward it. But if that's always worked great for you, what a blessing for you and your tenant, or you and your landowner. That's great.
Okay. Well, we do have some questions in the chat box, and let's start with any thoughts on how to handle negotiations with an absentee landlord? What works best other than in person?
We've had some talk about that as we prepared for this meeting. And one of the things that we talked about is how best to show them, for example, what you are doing. So although we were talking about doing FaceTime, there's even an app called Marco Polo where you can record a video and pictures and sort of drop it in. I'd call it a video voicemail. Drop it somewhere, and then your absentee landlord could pick it up and watch it when they wanted to. You could also take pictures and attach those as an email or even text pictures. I think communication preferences differ, but certainly that's something that you're going to want to hash out early and touch base with them. Probably more communication is better than less.
And we do have a lot of options these days.
We have many options. Yes.
Another question is, what are common practices in a lease to ensure tenant addresses prevents erosion or other land maintenance concerns?
I think, and we have many experts who might speak to this as well. My impression would be that this would be something to talk about. First of all, you need to talk about it up front. You need, if you think that there are places on your property that there is existing erosion, or that could be erosion or could erode easily, I would point that out to the person. I would show them the person, and I would lay out my expectations for what to do. I would not want to be somebody who, after the fact, not that that's worse than nothing, because you certainly do want to address it, but I would be careful about sort of using it as a gotcha. Now, if you have a good tenant, they're not going to want your land to erode either, because that hurts them as well. So I would come at it from a accommodative approach of, here's the situation we have, what can we do?
All right. I don't know if we're going to have another poll question if we have time for that this evening. If anybody wants to hang on, we're going to do one more. And it's, how can you, okay, that's the first one. We're going to find our next one. How can you communicate? And we did, or how do you communicate, whether you're a tenant or a landlord? And the options are in person, on the phone, in writing, video, as Amie was referencing, through a representative, or other. So we'll just let those trickle in. And wow, well, this one's pretty open and shut, Amie, it looks like.
That's very interesting. While we're waiting, I will tell you my contact info will be in the chat after the program. So we'll talk about it, but also it will be in the chat. So if there's ever anything I can do to help you, I would be more than glad to. So
yes,
appreciate being a guest and having this chance to appear in your homes tonight.
Yes, I'm certainly glad you were able to do that, Amie. We really appreciate it. Well, it looks like our poll is showing that in person, 87% is the most popular communication method, but it's also followed by on the phone, which is pretty high up there too, and then in writing. And we don't have any video callers here, or through a representative, and other. What do you think about that, Amie?
I'm not terribly surprised, and I would applaud this for those who can to do in person. You know, you just get a lot of communication in person.
Right.
To sit down, you get all that verbal, you get the nonverbal. It shows an investment of time and I think concern, and taking the time to be present in person is an investment in a relationship with that other person. So I'm not, especially a lot of these things maybe happen in small towns, right?
Sure.
So small towns are just kind of oriented that way. And so I'm not terribly surprised, but I think that's a good thing.
All right. Well, Amie, thank you so much for joining us. And thanks
Thank
to
you.
all of you for the great questions and participation. Wanted to remind you that a week from tonight, we're going to have another guest, and it will be our extension specialist, Jason Morris, who will talk about cash leases. Until then, have a good evening.